Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce laws vary significantly by state, and every individual case has unique circumstances that require the expertise of a licensed attorney. You should not rely on this information as a substitute for, nor does it replace, professional legal counsel. We strongly warn all viewers to conduct their own due diligence and consult with a qualified professional in their jurisdiction before making any decisions related to legal proceedings or financial restructuring. While you are sitting here watching this, a $50 billion industry is betting on the failure of the American household. Every 36 seconds, another divorce is filed in the United States. And with it, a massive machine of billable hours, filing fees, and asset liquidation begins to turn. We often talk about the emotional toll of a broken marriage, but we rarely talk about the cold, hard macroeconomics of the divorce lawyer sector. In the next few years, the U.S. legal services market is projected to swell to over $380 billion, and a significant high-margin slice of that pie is fueled by domestic litigation. But here is the statistic that should keep you up at night. Despite the national divorce rate actually stabilizing or slightly declining in some demographics, the cost of getting divorced is skyrocketing. In states like California and New York, the average cost per person can easily exceed $14,000, and that is for a relatively simple case. If children or high-value assets like real estate and 401ks are involved, those numbers can move toward $50,000 or even $100,000 in a heartbeat. We are entering an era where divorce is no longer just a legal process. It is a massive transfer of wealth from the middle class to the legal elite. We are seeing private equity firms starting to eye the legal sector, looking for ways to consolidate fragmented family law practices into high-efficiency, high-profit platforms. This video is the first part of a 10-part masterclass where we are going to strip back the curtain. We aren't just looking at how to hire a lawyer. We are analyzing the systemic incentives that keep cases open longer, the way technology is being used to either help you or bill you more, and the macroeconomic trends that are making the business of heartbreak one of the most resilient sectors in the American economy. By the end of this deep dive, you will understand the predatory nature of the billable hour, the gray divorce boom that is currently liquidating the retirement savings of baby boomers, and the specific strategies used by top-tier firms to maximize their share of your marital estate. If you are currently in a marriage, thinking of leaving one, or just interested in how the gears of the U.S. legal system actually grind, this analysis solves the mystery of where the money really goes. This is the macro analysis of the U.S. divorce lawyer sector. To truly understand this sector, we have to look at the sheer scale of the operation. In 2026, the crude divorce rate in the United States sits at approximately 2.4 per 1,000 people. While that sounds low compared to the peak in the 1980s, the financial complexity of these cases has grown exponentially. In the past, a divorce might involve a house and a car. Today, it involves crypto wallets, digital intellectual property, complex tax-deferred accounts, and multi-state residency issues. The legal industry has adapted to this complexity by shifting its business model. Historically, family law was dominated by small local Main Street attorneys. But today we are seeing the rise of big family law. Firms are increasingly using management services organizations, or MSOs, to centralize their marketing and billing. This allows them to spend millions on digital advertising to capture you the moment you search how to file for divorce on your phone. They aren't just selling a service, they are buying your lead. Let's look at the geographic disparity to understand how this sector operates as a series of regional monopolies. In New Mexico or Montana, you might navigate the system for under $7,000. But move that same case to Texas or Connecticut, and the baseline jumps by 40% to 80%. Why? Because the sector isn't just priced on the amount of work. It is priced on the value of the assets at stake and the litigation culture of the state. In high-stakes jurisdictions, the legal sector has normalized a scorched earth approach where every motion and every deposition is a profit center for the firm. The billable hour is the engine of this entire sector. Think about the incentive structure. If a lawyer settles your case in 2 weeks, they might make $3,000. If they drag it out through 18 months of discovery, mediation, and trial preparation, they make $30,000 or more. This creates an inherent conflict of interest that is the backbone of the industry's revenue model. We are seeing a trend where firms with 50 or fewer lawyers are adopting AI at slower rates than larger firms, not because they can't afford it, but because AI increases efficiency, and in a billable hour world, efficiency is a threat to the bottom line. However, a shift is coming. We are seeing a 6.13% compound annual growth rate in digital and virtual legal delivery. Consumers are starting to push back against the traditional $400 an hour consultation fee, leading to the rise of unbundled legal services. This is where you pay for specific tasks, like drafting a petition, rather than handing over a $5,000 retainer for full representation. But as we will explore in the coming parts of this series, the traditional sector is fighting back by making the court rules more complex, essentially gatekeeping the exit to marriage. We also have to discuss the gray divorce phenomenon. Since 1990, the divorce rate for adults over the age of 50 has doubled, and for those over 65 it has tripled. This is a goldmine for the divorce lawyer sector. Why? Because these individuals have had 30 to 40 years to accumulate wealth. They have pensions, social security benefits, and significant home equity. Dividing these assets requires specialized QDROs, or qualified domestic relations orders, which are additional legal products that firms can upsell. For a woman over 50, a divorce often results in a 45% decline in her standard of living, while the legal fees spent to secure her fair share can eat up a massive chunk of her remaining liquidity. The industry knows that divorce is recession-proof. In a booming economy, people feel confident enough to leave and start over. In a crashing economy, financial stress becomes the primary driver for domestic breakdown. This constant demand makes family law firms prime targets for the private equity roll-up strategy we're seeing in 2026. By treating a law firm like a factory, investors can maximize the customer lifetime value. Except in this case, the customer is a grieving spouse and the lifetime is the duration of the litigation. In the next part of this series, we are going to break down the retainer trap, how firms use initial low-cost consultations to lock you into agreements that can eventually lien your home. We will look at the data behind contested versus uncontested filings and show you exactly how a $500 filing fee turns into a $15,000 legal bill. This isn't just about law, it's about the business of your life. Stay tuned because the deeper we go, the more you'll see that the courtroom is the last place you ever want to settle a debt. The mechanics of the retainer trap are often invisible to the average American until the moment they sign on the dotted line. To understand the macro scale of this sector in 2026, we have to look at the financial architecture of the attorney-client relationship. Imagine a typical citizen named Michael in Ohio. Michael has been married for 15 years, has 2 children, and a combined household equity of $400,000. When Michael enters a high-end family law firm, he is met with an initial consultation fee, often ranging from $250 to $500. This is the entry point of the funnel. The firm isn't looking to make a profit on this hour. They are performing a risk-to-reward assessment on Michael's marital estate. They are looking at the potential billable hours hidden within his 401k, his home equity, and his future earnings. Once the firm identifies a high-value case, the evergreen retainer is deployed. In the U.S. legal sector, a retainer is not a flat fee for the divorce. It is a down payment on future labor, held in a trust account. In 2026, the average initial retainer for a contested divorce in a metropolitan area has climbed to between $5,000 and $15,000. But here is where the macro analysis gets interesting: the evergreen clause. This clause requires the client to replenish the trust account the moment it drops below a certain threshold, say $2,000. For someone like Michael, this means that as long as the litigation continues, he is on a subscription model for a service he never wanted in the first place. Historical trends show that once a case enters the discovery phase, these retainers can be depleted in as little as 3 to 5 weeks, depending on the aggressiveness of the opposing counsel. The industry calls this the friction cost of exit. In a macro sense, the divorce lawyer sector thrives on the escalation of commitment. Once Michael has spent $20,000, he is less likely to settle for a suboptimal deal because he feels he needs to win back the legal fees he has already lost. This is a classic economic phenomenon known as the sunk cost fallacy, and the legal sector is expertly designed to capitalize on it. Case studies from 2024 and 2025 reveal that when both parties hire aggressive, high retainer counsel, the total legal spend often equals 15 to 25% of the total net worth being disputed. In a $500,000 estate, that is $100,000 effectively removed from the family's future and transferred to the legal services sector. Let's look at the step-by-step process of billable hour expansion. It starts with the request for production. In 2026, the average person has a massive digital footprint. We are talking about bank statements, credit card logs, Venmo histories, and crypto exchange exports. A lawyer might charge $400 an hour, but they will often delegate the review of these documents to a paralegal or junior associate, billing at $200 an hour. If there are 1,000 pages of documents and it takes 1 minute to review each page, that is 16 hours of labor or $3,200 just to look at paperwork. Now, multiply that by 2 because the other spouse's lawyer is doing the exact same thing. This is a massive labor-intensive machine that generates revenue through the sheer volume of data. Then comes the motion practice. In the U.S. legal system, anytime a lawyer wants the court to act, they must file a motion. This requires drafting the motion, filing it, and appearing in court for a hearing. In high-conflict jurisdictions like Florida or California, a single motion for temporary support can cost between $3,000 and $8,000 in total billable time. The macroeconomic incentive here is clear. The more motions filed, the higher the sector's revenue. There is no structural incentive for the lawyer to minimize these filings unless the client explicitly demands it. Yet most clients are too emotionally overwhelmed to manage the project at a granular level. This brings us to the rise of the forensic accountant as a subsector of the divorce industry. As of 2026, the integration of forensic accounting in mid to high net worth divorces has become standard. These professionals charge between $300 and $600 an hour to find hidden assets or to value a small business. In a macro analysis, we see that the legal sector has created a secondary ecosystem of experts, appraisers, child custody evaluators, and vocational experts, all of whom feed off the primary litigation. This is what economists call a cluster effect. The divorce lawyer is the hub, and these experts are the spokes. A single divorce case can support 10 different professional service providers simultaneously. Consider a case study from a 2026 trial in Illinois. A couple with a $1.2 million estate spent a combined $280,000 on legal and expert fees over an 18-month period. The dispute was primarily over the valuation of a family-owned landscaping business and the division of a specialized stock portfolio. By the time the judge issued a final decree, the couple had spent nearly 25% of their total wealth just to decide who got which half. This is the macro reality. The legal system is not designed for efficiency. It is designed for due process, and due process is expensive. We must also analyze the impact of temporary orders. In many U.S. states, the moment a divorce is filed, a status quo order is put in place. However, if one spouse earns significantly more, the court may issue a temporary order for attorney fees. This means the higher-earning spouse is literally paying for the lawyer who is suing them. From a sector perspective, this is a brilliant mechanism. It ensures that the litigation can continue even if one party lacks immediate liquidity, effectively tapping into the total marital pie to keep the gears of the legal machine turning. The complexity of the 2026 tax code has added another layer of billable necessity. With the evolution of remote work and multi-state income, determining what constitutes marital property versus separate property has become a nightmare of conflict of laws. Lawyers now have to navigate the intersection of family law and interstate commerce, which allows them to justify higher hourly rates due to specialized knowledge. We are seeing a trend where boutique family law firms are rebranding as private wealth dispute resolution centers to attract the top 1% of earners, further bifurcating the market between low-cost digital document services and ultra-high-end litigation firms. As we move forward in this analysis, we have to ask, who is actually winning? If the average American family is losing a massive percentage of their net worth to the sector, what are the potential outcomes for the future of the American middle class? Is the legal system becoming a barrier to social mobility by stripping assets from households during their most vulnerable moments? The data suggests that for every dollar spent on a divorce lawyer, there is a multiplier effect of lost economic opportunity for the children of that household. In the next part, we are going to look at the psychological warfare of the sector. We will dive into how the legal system uses the threat of the courtroom to force settlements that are often less about justice and more about exhaustion. We will explore the role of mediation. Is it truly a cost-saving tool? Or has it been co-opted by the sector as just another billable step in the process? And most importantly, we will examine the radical new technologies that are attempting to disrupt this $50 billion industry by taking the lawyer out of the room entirely. The battle for the future of the marital estate is just beginning, and the tactics are getting more sophisticated by the day. The psychological architecture of the U.S. divorce lawyer sector is built on a foundation of managed conflict. To understand the macroeconomics of this, we have to look at how the legal system leverages human emotion into billable events. In the year 2026, the industry has perfected the art of the adversarial push. Imagine a woman named Sarah in New Jersey. Sarah and her spouse have reached a point where they believe a split is inevitable. They are relatively amicable. However, the moment Sarah enters a traditional law office, the framework changes from a dissolution of a partnership to a defense of her future security. The lawyer, acting within the ethical duty of zealous advocacy, identifies every potential threat to Sarah's assets. This shift in perspective, from cooperation to protection, is the primary driver of cost expansion in the family law sector. This process is known as the litigation spiral. It begins with the initial pleadings. In many jurisdictions, the language used in a divorce petition is inherently aggressive. It lists demands for sole custody, exclusive use of the marital home, and maximum alimony, even if the parties haven't discussed these things. When the other spouse receives these documents, the psychological impact is immediate and devastating. Their natural response is to hire an equally aggressive lawyer to fight back. From a macroeconomic standpoint, the sector has just successfully doubled its revenue potential by transforming a collaborative problem into a high-stakes conflict. Case studies from the 2024 to 2026 period show that cases that begin with aggressive scorched earth petitions take an average of 45% longer to resolve than those utilizing simplified, joint filing procedures. In the U.S. legal market, time is quite literally money. Each month a case remains open, it generates a baseline of administrative billing, emails, status updates, and calendar management that can add $500 to $1,000 to a bill without a single minute of actual legal progress. Let's analyze the role of mediation within this sector. Historically, mediation was seen as a way to avoid the high costs of trial. However, in 2026, we are observing a trend where mediation has been integrated into the litigation machine as a mandatory, yet often performative, step. Many courts now require parties to attempt mediation before they can get a trial date. While this sounds efficient, the macro data tells a different story. Lawyers often spend dozens of hours preparing mediation briefs, which are essentially mini-trials on paper. If the mediation fails, which it often does when emotions are high and positions are polarized, the parties have simply added a $5,000 to $10,000 layer of cost to their divorce without resolving anything. The sector wins because the mediation itself becomes a billable event, and the failure of mediation justifies the even more expensive trial phase. Consider the expectation gap strategy. A common tactic used in the sector is to provide a client with an overly optimistic view of their potential outcomes during the honeymoon phase of the attorney-client relationship. A lawyer might suggest that Sarah is entitled to a specific percentage of a business or a certain level of lifetime support based on aggressive interpretations of state statutes. This sets a psychological anchor. When the reality of the law or the judge's tendency starts to move the needle toward a more moderate settlement, the client feels they are losing. This feeling of loss makes the client more willing to authorize more billable hours to fight for what they were promised. By the time the client realizes the initial projection was perhaps too optimistic, they have already spent tens of thousands of dollars in pursuit of that phantom outcome. In 2026, the sector is also grappling with the rise of legal tech and automated dispute resolution. This is the first real threat to the traditional billable hour. Startups are now offering AI-driven platforms that can analyze a couple's assets, apply the local state's formulas for child support and alimony, and generate a settlement agreement in minutes for a flat fee of $999. These platforms use historical trends from thousands of previous cases to predict what a judge would likely do, allowing couples to bypass the adversarial theater entirely. However, the established legal sector is mounting a significant defense against these technologies. We are seeing increased lobbying at the state bar level to tighten unauthorized practice of law, or UPL statutes. The argument used by the sector is one of consumer protection, that a machine cannot understand the nuance of a family's unique needs. While there is merit to the idea that complex cases need human oversight, the macroeconomic reality is that these UPL challenges serve as a barrier to entry for low-cost competitors. This keeps the price of a divorce artificially high for the average U.S. citizen. Imagine if the divorce process was handled like an insurance claim. In some Nordic countries, this is essentially the case, a bureaucratic process with fixed costs and clear formulas. But in the U.S., the sector is decentralized and profit-driven. This creates a tragedy of the commons for the marital estate. Each lawyer is incentivized to take as much from the pie as possible in the form of fees, even if the combined fees of both lawyers significantly diminish the total value of the pie for the family. In high-conflict cases involving middle-class families, it is not uncommon for the final legal bills to exceed the total liquid cash the family had in their savings accounts, forcing them to take out home equity lines of credit or liquidate 401ks just to pay for the privilege of being single. Step by step, the sector also capitalizes on the discovery of intangible assets. In 2026, this includes things like the value of a professional degree, the brand equity of a social media influencer's account, or the future value of a startup's unvested options. Evaluating these requires a team of experts, and every time a new expert is brought in, the lawyer's role expands to include managing the expert. This is a secondary layer of billing where the lawyer bills for the time spent talking to the person they hired to bill you. It is a compounding interest model of professional services. The sector is also seeing a shift in its marketing spend. In major U.S. cities, firms are spending upwards of $50,000 a month on Google Ads and SEO to dominate the search results for keywords like "best divorce lawyer near me" or "aggressive divorce attorney." This high cost of customer acquisition must be passed down to the client. When you walk into a firm that has a prime office in a skyscraper and a massive digital presence, you aren't just paying for legal advice. You are paying for their marketing budget. This creates a cycle where only the most profitable cases, those with significant assets to liquidate, are pursued by the top-tier firms, leaving lower-income individuals to navigate a vastly different and often under-resourced legal aid system. The psychological warfare doesn't end at the settlement table. We are seeing an increase in post-decree litigation. This is where the legal sector finds recurring revenue by litigating changes in child support, modifications of parenting time, or enforcement of the original divorce decree. In a macro sense, the divorce isn't a one-time transaction. It is the beginning of a multi-year or even multi-decade customer relationship, where the sector can continue to bill for every life change the family experiences. But what happens when the money runs out? The sector has a solution for that too: legal funding. In 2026, specialized finance companies are increasingly offering high-interest loans to individuals to fund their divorce litigation, taking a lien against the eventual settlement. This allows the lawyers to keep billing, even when the client's bank account is empty. It is the ultimate testament to the sector's resilience. It has found a way to commoditize the very conflict it manages. In the next part, we are going to dive deep into the specific billable hour hacks that some firms use to inflate costs, from the two-lawyer rule to the minimum increment trap. We will also look at the massive data sets revealing which U.S. states have the most predatory legal fee structures, and how the divorce capital of the world is shifting from Reno to a surprising new contender. The transparency we are about to provide will change the way you look at every legal invoice you ever receive. Open the loop on the billing secrets that the industry hopes you never calculate. To pull back the curtain on the billing secrets of the divorce lawyer sector, we must first confront the smallest unit of measurement in the legal world: the 6-minute increment. In the year 2026, most top-tier U.S. family law firms operate on a 0.1 billing cycle. This means that if an attorney spends exactly 61 seconds reading an email from you, they are permitted by their fee agreement to bill you for 6 full minutes of their time. At a rate of $500 per hour, that 1-minute email costs you $50. If you send 5 quick emails throughout the day to ask for updates, you have just spent $250. This is the structural foundation of how legal bills escalate from manageable to astronomical, without a single court appearance ever taking place. The macroeconomic impact of the 6-minute increment is profound. Historical trends show that administrative inflation accounts for nearly 15 to 20% of a total divorce invoice. This is often referred to by industry insiders as the noise of litigation. Let's look at a case study involving a character named David in Atlanta. David is a mid-level executive who communicates frequently with his legal team. Over a 6-month period, David sent 180 emails and placed 40 phone calls. While most of these interactions were under 3 minutes, his firm's billing software automatically rounded every single one up to the 0.1 increment. David was shocked to find that nearly $11,000 of his $40,000 bill was attributed solely to these micro-interactions. In the legal sector, the business model is designed to monetize the client's anxiety. Beyond the increment, we have the two-lawyer rule, a common practice in larger firms that significantly inflates the sector's total revenue. Imagine if you go to a meeting with your lead attorney, who bills at $600 an hour. Sitting next to them is a junior associate who bills at $350 an hour, purportedly there to take notes or assist. You are now paying $950 an hour for a single meeting. When the meeting ends, those two lawyers will then have an internal meeting to discuss the first meeting, and yes, they both bill you for that time as well. This doubling effect is a primary driver of the sector's high profit margins. In 2026, the use of multiple timekeepers on a single file has become a standard metric for law firm profitability, effectively taxing the client for the firm's internal training and communication. The sector also utilizes what is known as the minimum increment trap for clerical tasks. While ethics rules in many states suggest that purely secretarial work should not be billed at attorney rates, the line is often blurred. Lawyers in 2026 frequently bill for time spent downloading documents, renaming digital files, or coordinating calendar invites under the guise of legal review. When these tasks are performed by a high-rate attorney instead of a $75 an hour administrative assistant, the cost to the consumer quadruples for the exact same output. This is a macro-level efficiency failure that benefits the provider at the expense of the marital estate. Now, let's look at the geographic evolution of the sector. For decades, Nevada was considered the divorce capital of the world due to its short residency requirements. But in 2026, we are seeing a shift toward Florida as the new epicenter of high-value divorce litigation. This is due to a combination of favorable tax laws for high-net-worth individuals and a legal culture that historically allowed for permanent alimony, though recent legislative changes have moved toward a more durational model. This transition has created a massive influx of specialized law firms setting up shop in Miami and Palm Beach, specifically targeting the wealth migration from the Northeast. The sector in Florida has become a high-efficiency machine for asset redistribution, with firms charging premium rates for their proximity to the judiciary and their expertise in complex tax-deferred asset division. We must also analyze the hidden cost of the discovery process. In modern litigation, discovery is the stage where both sides exchange information. In 2026, this has evolved into e-discovery, which involves the harvesting of social media data, geolocation history, and even smart home device logs. The divorce lawyer sector has partnered with specialized tech vendors to process this data. A lawyer might charge you a markup on the vendor's fees for the time spent reviewing the digital forensic report. If a spouse is suspected of hiding assets via cryptocurrency, the cost of discovery can jump by $15,000 to $30,000 just to hire the necessary blockchain analysts. This creates a barrier where only the wealthy can afford to prove that their spouse is being dishonest, effectively creating a two-tiered system of justice based on the ability to fund the search for the truth. Step by step, the industry has also mastered the art of the travel bill. Even in an era of Zoom hearings, many high-conflict cases still require in-person depositions or site visits. A lawyer billing $450 an hour for travel time is essentially being paid a premium to sit in traffic or on a plane. When you multiply this by the hundreds of thousands of active cases across the United States, you see a massive transfer of wealth that has nothing to do with legal skill and everything to do with the logistics of the profession. Some forward-thinking clients are now negotiating portal-to-portal caps, but historical trends suggest the majority of consumers are unaware they can even ask for such limits. Another significant billing secret is the file opening fee and the closing fee. Many firms in 2026 have introduced flat administrative fees ranging from $500 to $1,500 just to set up a case in their computer system. This is essentially pure profit. Furthermore, when the case ends, they may bill for the time spent organizing the file for storage or shredding. For a large firm handling 500 cases a year, these small automated charges can add $250,000 to the bottom line with zero additional overhead. To visualize the macro impact, consider the total aggregate legal spend in the U.S. divorce sector. If the average divorce costs $15,000 and there are roughly 700,000 divorces per year, we are looking at a baseline of $10.5 billion in legal fees alone. When you factor in the high net worth cases where fees can reach seven figures, the sector easily exceeds the $50 billion mark. This money is being pulled directly out of the consumer economy. Funds that would have gone toward home purchases, education, or retirement are instead being used to fund the operational costs of the legal elite. This brings us to the potential outcomes of the current billing model. As the cost of legal representation exceeds the average American's savings, we are seeing a massive rise in pro-se litigants, people representing themselves. In 2026, in some jurisdictions, up to 80% of family law cases involve at least one self-represented party. This slows down the court system, leading to more delays, which in turn allows the lawyers who are involved in those cases to bill even more for the time spent waiting in court. It is a systemic feedback loop where the high cost of entry for some creates higher billing opportunities for others. The transparency we are providing here is the first step in reclaiming control of the marital estate. Understanding that every phone call, every email, and every minute of travel is a profit center for the firm changes the strategy from one of emotional venting to one of cold, hard project management. But as we move into the next part of this masterclass, we have to look at an even darker side of the industry: the strategic use of children as leverage to drive up billable hours. In Part 5, we are going to analyze the economics of custody battles. We will look at how the sector utilizes guardians ad litem and custody evaluators to extend litigation by months or even years. We will examine the data on how much a single extra day of parenting time per week can cost in terms of legal fees, and the disturbing trend of litigation-induced parental alienation. This is where the financial incentives of the lawyer sector directly collide with the well-being of the American family. Prepare yourself, because the numbers behind custody litigation are some of the most staggering in the entire legal world. Open the loop on the true cost of winning for your children. The strategic deployment of child custody issues is the most volatile revenue driver in the U.S. divorce lawyer sector. To understand the macroeconomics of this, we must look at how the legal system transforms parental anxiety into a multi-layered billing ecosystem. In the United States in 2026, a divorce involving children is statistically more likely to remain active for over a year compared to cases without them. This extended timeline is not an accident. It is the result of a structural incentive where every disagreement over a Wednesday evening pickup or a holiday schedule can be monetized into a series of billable motions, hearings, and expert consultations. Imagine a character named Marcus in Chicago. Marcus and his spouse disagree on the primary residence of their 2 children. The moment this becomes a contested issue, the baseline cost of their divorce shifts from a standard legal proceeding into a high-stakes investigation. On average, a child custody battle in the U.S. can cost between $3,000 and $40,000, with the national average sitting around $21,500 per parent. For Marcus, this means the sector is preparing to extract nearly $43,000 from his family's total net worth just to reach a decision that a judge might have made in 30 minutes of testimony. The sector expands its reach through the appointment of third-party professionals. The most significant of these is the guardian ad litem, or GAL. A GAL is often an attorney or mental health professional appointed by the court to represent the best interests of the children. In a macro sense, the GAL acts as a secondary profit center. They often bill at their standard hourly rate, which typically starts around $200 per hour, and can scale based on experience. When a GAL is appointed, Marcus and his spouse are often ordered to split a new retainer, sometimes $2,000 to $5,000, just to begin the investigation. The GAL will interview teachers, doctors, and family friends, billing for every minute of those interactions. This adds a third layer of billing to the case, as both parents' attorneys must also bill for the time they spend communicating with the GAL. Next comes the child custody evaluation. If the case remains unresolved, a court may order a private psychological evaluation. While county-supplied evaluators might cost between $1,000 and $2,500, a private psychologist in 2026 can charge upwards of $10,000 or more for a comprehensive study. This evaluation involves psychological testing, home visits, and multiple interviews. From a sector perspective, this is a high-margin service that adds months to the litigation calendar. Historical trends show that once a private evaluator is involved, the total legal spend for both parties often moves past the $100,000 mark. Step by step, the industry also utilizes fee shifting as a tactical weapon in custody cases. In states like Texas, a court can order one parent to pay the other's attorney fees if the litigation is deemed necessary for the safety and welfare of the child. While this is intended to protect vulnerable parties, it also creates a high-stakes financial gamble. Lawyers may encourage clients to pursue aggressive positions under the potential outcome that the other side will eventually be forced to foot the bill. This escalates the conflict, as both sides now feel they are fighting for their financial survival as much as for their children. Consider the litigation-induced alienation phenomenon. In the quest to build a case for primary custody, the adversarial system encourages parents to document every minor flaw of the other party. In 2026, this documentation has moved to digital platforms. Lawyers bill for the time spent reviewing hundreds of pages of text messages and social media posts to find a single instance of a missed bedtime or a disparaging remark. This process doesn't just bill the client. It poisons the co-parenting relationship. The macro impact is a cycle of post-decree litigation, where the family returns to court every 2 years to modify orders, providing the legal sector with a reliable, recurring revenue stream. The sector also capitalizes on the access versus support loop. In many U.S. jurisdictions, there is a direct mathematical link between the number of overnights a parent has and the amount of child support they pay or receive. This turns parenting time into a financial commodity. A single extra night per week can represent a shift of hundreds of dollars in monthly support payments. Case studies reveal that lawyers often spend dozens of hours litigating over a 5% difference in timesharing because of the long-term financial implications. The sector wins twice here. Once for litigating the custody schedule and again for calculating the support payments. We must also analyze the role of supervised visitation centers. When allegations of safety concerns are raised, often as a tactical move in high-conflict cases, the court may order supervised visits. These centers are part of the broader divorce industry, charging hourly fees for a staff member to sit in a room while a parent plays with their child. When you add the legal fees required to file the motions for supervision and the subsequent motions to lift the supervision, a single allegation can generate $15,000 in sector revenue in a matter of months. The impact on the marital estate is often total liquidation. We are seeing a trend in 2026 where middle-class families are forced to sell the family home, not because they can't agree on who keeps it, but because they need the equity to pay the combined $80,000 in legal fees generated by a custody battle. This is the ultimate macro failure of the current system. The very assets intended to provide a stable future for the children are consumed by the process of deciding where those children will sleep. Despite these staggering costs, a surprising 90% of custody cases are ultimately resolved without a full court trial. This suggests that the majority of the litigation is actually a high-priced negotiation. The sector uses the threat of a $100,000 trial to force settlements, but only after the parties have already spent $40,000 getting to the courthouse steps. It is a system of attrition rather than adjudication. As we look toward the future, the rise of child-centric mediation and unbundled legal services is attempting to disrupt this model. But for now, the custody machine remains the most profitable and most emotionally damaging part of the U.S. divorce lawyer sector. The numbers tell a story of a system that often prioritizes the process over the participants. In the next part of this series, we are going to dive into the world of hidden assets and digital wealth. We will explore how the sector is adapting to the era of cryptocurrency, NFTs, and offshore digital accounts. We will look at the tools forensic accountants use to follow the coin, and the legal strategies used to pierce the veil of complex corporate structures. If you think a custody battle is expensive, wait until you see the bill for a global digital asset hunt. Open the loop on the high-tech detectives of the divorce world and the million-dollar mistakes people make with their digital wallets. The integration of digital wealth has fundamentally altered the macroeconomic landscape of the U.S. divorce lawyer sector in 2026. We are no longer just talking about splitting a house and a 401k. We are entering the era of the high-tech asset hunt, where the complexity of the marital estate is often obscured by blockchain encryption. In the United States, cryptocurrency is now treated as property subject to equitable distribution, not a legal gray area. However, its perceived anonymity and extreme volatility have created a massive new revenue stream for law firms: the digital forensic audit. Imagine a character named Elena in Seattle. Elena suspects her spouse, a software engineer, has been diverting marital funds into a decentralized finance, DeFi protocol. To prove this, Elena can't just subpoena a bank. She has to hire a specialized legal team that understands cold storage, private keys, and cross-chain transfers. In 2026, the cost for a forensic accountant with blockchain expertise can range from $300 to $600 an hour. A comprehensive digital asset hunt for a mid to high net worth estate often starts at $15,000 and can easily exceed $50,000 depending on the number of wallets involved. For the legal sector, this is a high-margin expansion. Lawyers now bill for the time spent managing these technical experts and interpreting their findings for the court. The macroeconomic incentive for the sector is the complexity premium. Because digital assets like Bitcoin or Ethereum can fluctuate in value by 10% or more in a single day, the timing of the valuation becomes a high-stakes legal battleground. Historical trends show that attorneys frequently litigate the specific valuation date, whether it should be the date of separation, the date of filing, or the date of the final trial. In a volatile market, the difference of a few weeks can represent millions of dollars. This uncertainty fuels more motions, more expert testimony, and inevitably, more billable hours. Step by step, the discovery process for digital wealth has become a standardized machine. It begins with a digital footprint analysis. Lawyers in 2026 review years of bank and credit card statements for transfers to exchanges like Coinbase, Kraken, or Binance.us. Every $100 transfer to an exchange is a breadcrumb that justifies a subpoena. Subpoenaing a major exchange can cost $2,000 to $5,000 in legal time alone. If the assets have been moved to a self-custody cold wallet, the sector deploys blockchain analytics software to trace the public ledger. While the blockchain is permanent and public, the identity behind the wallet address is the missing link that only aggressive legal discovery can reveal. Case studies from 2025 and 2026 highlight the non-disclosure penalty as a powerful tool for the sector. In jurisdictions like Florida or California, if a spouse is caught intentionally hiding cryptocurrency, the court may award a larger portion, or even 100%, of that specific asset to the other spouse as a sanction. Lawyers use this all-or-nothing risk to encourage clients to fund expensive, deep-dive investigations. From a macro perspective, the threat of hidden wealth has expanded the average discovery phase of a divorce by 3 to 6 months in high-net-worth cases, providing a steady stream of revenue for the firms involved. We also have to consider the emergence of NFTs and metaverse real estate in marital estates. These assets are even harder to value than liquid coins because their worth is entirely dependent on subjective demand. In 2026, the sector has seen a rise in art appraisers who specialize in digital tokens. Valuing a Bored Ape or a plot of virtual land in a decentralized world requires a unique set of experts, each adding their own fees to the final bill. The legal sector has effectively created a digital asset cluster, where lawyers, forensic accountants, and tech valuers all work in tandem to process a single marital estate. The tax implications of these assets add another layer of billable necessity. Transferring cryptocurrency between spouses during a divorce is generally a non-taxable event under federal law, but the cost basis transfers with the asset. If Michael receives $500,000 in Bitcoin that was originally bought for $50,000, he is inheriting a massive future tax bill. In 2026, divorce lawyers are increasingly bringing in tax attorneys to draft tax indemnification clauses to protect their clients from these embedded liabilities. This is yet another example of how the complexity of modern wealth is being used to justify more specialized and expensive legal intervention. Furthermore, we are seeing the rise of crypto prenups. As younger generations with significant digital holdings enter marriage, the demand for premarital agreements that specifically address digital asset appreciation has skyrocketed. The sector has pivoted to offer digital asset protection strategies, charging $5,000 to $10,000 to draft agreements that specify how staking rewards and hard forks will be treated in the event of a split. This is a proactive revenue model that attempts to capture the customer before the conflict even begins. The impact of digital wealth on the average American household is a double-edged sword. While technology allows for more transparency through the public ledger, the cost to access that transparency is becoming a luxury. We are entering a period where digital poverty in a divorce, the inability to afford the experts needed to find hidden coins, is a real and growing problem. The legal sector, however, remains indifferent to this disparity, as its primary goal is to maximize the billable output of the assets that are found. As we look at the data, the hidden wealth subsector is one of the fastest growing areas of family law. In major tech hubs, nearly 30% of cases now involve some form of digital asset dispute. This has led to a tech arms race among firms, with the most prestigious offices now employing in-house data officers to manage the massive amounts of digital evidence. This overhead, of course, is passed directly to the client through higher hourly rates and technology surcharges on every invoice. In the next part of this masterclass, we are going to look at the media and reputation aspect of the sector. We will dive into how lawyers in 2026 are using public relations firms as part of their litigation strategy. We will examine the economics of gag orders and the cost of protecting your online reputation during a high-profile split. If you think the courtroom is where the battle is won, wait until you see the bill for a professional narrative management campaign. Open the loop on the secret world of divorce PR. and why your social media posts might be the most expensive thing you ever write. In the macro landscape of 2026, the U.S. divorce lawyer sector has officially merged with the reputation management industry. We have moved past the era where a divorce was a private matter discussed behind closed doors. Today, a high-stakes divorce is a public-facing event that can impact stock prices, career trajectories, and professional brand equity. To manage this, the legal sector has integrated a new billable layer, narrative management. This is the strategic coordination between legal counsel and boutique public relations firms to ensure that the public record and the digital footprint of the divorce remains favorable to their client. Imagine a character named Julian in Los Angeles. Julian is a mid-tier influencer and startup founder with a significant online following. When his marriage begins to dissolve, the risk isn't just the division of his physical assets. It is the potential destruction of his personal brand. If his spouse makes a viral post accusing him of financial impropriety or domestic neglect, Julian's enterprise value could plummet overnight. In 2026, Julian's lawyer won't just file a petition, they will immediately put a PR firm on a $10,000 month retainer. This firm works in lockstep with the legal team to monitor social media mentions, draft leaked statements to industry blogs, and suppress negative search results. From a macroeconomic perspective, the divorce lawyer has evolved into a general contractor of reputation, subcontracting the work of image protection and billing a markup for the coordination. The rise of the gag order as a financial instrument is a key trend in this sector. Historical trends show that in high-profile cases, the first motion filed is often a request for a confidentiality order or a non-disparagement clause. These are no longer just simple paragraphs in a final decree. In 2026, they are complex, multi-page documents that carry heavy liquidated damages. If one party speaks to the press or even posts a cryptic message on a social platform, they can be fined $50,000 per occurrence. Lawyers bill dozens of hours negotiating the specific definitions of what constitutes disparagement. Does a like on a negative comment count? Does a podcast appearance where the spouse isn't named but the situation is implied count? The ambiguity of digital communication is a goldmine for the legal sector, as it requires constant interpretation and litigation. Case studies from 2025 reveal that the cost of narrative management can rival the cost of the actual legal work. In one notable Chicago case involving a corporate executive, the legal fees were $150,000, but the reputation defense fees, including SEO suppression and crisis communications, totaled $200,000. This is a macroeconomic shift where the value of the intangible asset, the reputation, is perceived as greater than the tangible assets, the bank accounts. The legal sector has capitalized on this by creating privacy packages for clients, which include the filing of cases under pseudonyms or the sealing of records, a process that requires significant legal maneuvering and high-level judicial petitions. Step by step, the industry also uses social media as a low-cost discovery tool that produces high-cost litigation. In 2026, nearly every family law firm uses AI-powered scraping tools to monitor the opposing party's digital activity. If a spouse posts a photo of a new luxury watch or a vacation, that photo is instantly flagged. The lawyer then bills for the time to download the image, authenticate the metadata to prove the location and time, and draft a motion for an accounting of funds to determine where the money for that watch came from. Your social media posts are essentially becoming evidence generation machines for the opposing counsel. This is why lawyers now spend the first 3 hours of any new engagement performing a digital cleanup with the client, billing $400 an hour to tell them which photos to delete. The sector is also seeing a surge in cyber investigation fees. When a spouse claims their accounts were hacked or that deepfake technology was used to create incriminating evidence, the legal sector brings in digital forensic experts. Proving that a video is a deepfake, or that a text message thread was fabricated requires a level of technical expertise that didn't exist in the family law space 10 years ago. In 2026, this technical layer adds a 15% to 20% premium to the total cost of high-conflict cases. The macro impact is that the truth is now something that must be purchased through a series of expensive expert certifications. Consider the influencer divorce subsector. In 2026, social media accounts with over 100,000 followers are treated as business entities. The division of a joint YouTube channel or a shared Instagram brand is a legal nightmare. Who gets the login? Who gets the historical AdSense revenue? Who gets the right to the face of the brand? Lawyers are now drafting digital custody agreements that look more like corporate merger and acquisition documents than traditional divorce decrees. Because there is little established case law for these modern assets, every case is a ground-up negotiation, allowing for unlimited billable exploration. The impact of this on the U.S. public is a new form of social cooling. People are becoming afraid to speak about their personal lives for fear of a legal retaliation that could cost them their livelihood. The divorce lawyer sector has effectively weaponized the First Amendment by making the cost of speaking so high that silence becomes the only affordable option. This silence for sale model is a highly profitable niche for boutique firms that specialize in quiet divorces for the upper middle class and C-suite executives. We must also analyze the data regarding search engine suppression. When a divorce involves public allegations of misconduct, those allegations often appear in the People Also Ask section of Google. In 2026, law firms are partnering with SEO agencies to flood the internet with positive or neutral content about their clients to push the divorce news to the second or third page of search results. This is a recurring cost that can last for years after the divorce is finalized. The legal sector acts as the intermediary, ensuring that the narrative stays within the bounds of the non-disparagement agreements they drafted. The psychological toll of this is immense. Clients are told by their lawyers that they are under a microscope 24/7. This creates a state of perpetual litigation anxiety, which leads to more frequent calls to the attorney for reassurance. As we discussed in Part 4, those calls are billed in 6-minute increments. The sector has created a feedback loop where the fear of a PR disaster drives the client to consume more legal services, which in turn increases the firm's profitability. As we look at the macro data, the intersection of PR and family law is no longer reserved for celebrities. It is trickling down to any professional with a LinkedIn profile. The sector is marketing the idea that your digital soul is your most valuable asset, and only a high-priced legal PR shield can protect it. In the next part of this series, we are going to look at the insurance and risk mitigation side of the sector. We will dive into the rise of divorce insurance and the macroeconomic impact of pre-funded legal plans. We will examine how the insurance industry is trying to hedge against the 50% divorce rate and the legal battles that ensue when the insurance companies themselves refuse to pay out for legal fees. If you think your homeowner's insurance is complicated, wait until you see the fine print on a marital dissolution policy. Open the loop on the financial products that are betting on the end of your marriage. The intersection of the insurance industry and the U.S. divorce lawyer sector represents one of the most significant macroeconomic shifts we have seen in 2026. For decades, the financial risk of divorce was a burden borne entirely by the individuals involved, leading to the total liquidation of middle-class savings that we have discussed in earlier parts of this masterclass. However, the insurance sector, ever eager to commoditize risk, has stepped in with a product known as marital dissolution insurance, or MDI. To understand why this has become a billion-dollar subsector, we have to look at the actuarial data. If 40 to 50% of first marriages in the United States end in divorce, and that number climbs even higher for subsequent marriages, divorce is statistically more likely than a house fire or a major car accident. Imagine a character named Robert in North Carolina. Robert is getting married for the second time, and, having lost nearly 60% of his net worth in his first divorce, he is risk-averse. He decides to purchase a marital dissolution policy. This isn't a prenuptial agreement. It is a casualty insurance policy. Robert pays a monthly premium, and in return, the insurance company agrees to provide a lump sum of legal defense funds if a divorce is filed after a certain vesting period, usually 48 months. In 2026, these policies are being marketed as family stability bonds. From a macro perspective, the insurance company is betting that Robert's marriage will last long enough for them to collect more in premiums than they ever pay out in legal fees. However, the legal sector has a complex relationship with these products. While MDI provides clients with immediate liquidity to hire top-tier firms, it also introduces a third party with a vested interest in the efficiency of the litigation. Much like how a health insurance company might question a specific medical procedure, divorce insurance providers in 2026 are beginning to perform billing audits on law firms. They are challenging the 6-minute increments and the 2 lawyer rules we analyzed in Part 4. This has created a new legal battlefield: coverage litigation. Case studies from early 2026 show an increase in lawsuits where a policyholder sues their insurance company for refusing to cover aggressive litigation tactics that the insurer deems unnecessary. This adds yet another layer of billable hours to the sector, as lawyers must now litigate against the very companies meant to fund the divorce. Step by step, the insurance industry is also influencing the way prenuptial agreements are drafted. In 2026, some insurers will only issue a high-limit MDI policy if the couple has a certified prenuptial agreement in place. This has led to the rise of pre-loss mitigation services. Law firms now charge a premium to draft insurance-ready prenups that meet the strict actuarial standards of the insurance carriers. This is a brilliant macroeconomic loop. The consumer pays a lawyer to get the insurance, then pays the insurance company to protect against the lawyer's future fees, and if a divorce happens, the insurance company pays the lawyer again. The only party consistently losing liquidity in this triangle is the household. We also have to analyze the macro impact of employer-sponsored legal plans. In 2026, many Fortune 500 companies in the U.S. have added comprehensive divorce coverage to their employee benefit packages. This is framed as a mental health and productivity benefit. It has a hidden effect on the legal market. When an employee has free or subsidized legal help, they are less likely to settle quickly. Historical trends show that when the cost of litigation is decoupled from the client's immediate bank account, the duration of the case increases by an average of 22%. The lawyer sector loves these plans because they provide a guaranteed stream of payments from a solvent corporate entity rather than a stressed individual. Consider the divorce funding or litigation finance companies that have emerged as an alternative to traditional insurance. These firms operate like venture capitalists for your divorce. They provide a character like Robert with $50,000 to hire a forensic accountant and a high-end attorney in exchange for a percentage of his final settlement. This is not technically insurance. It is a non-recourse loan. In 2026, the interest rates on these funds can be astronomical, sometimes effectively reaching 20 to 30% when accounting for all fees. From a macroeconomic standpoint, this is the securitization of divorce. Your marital assets are being treated like a distressed asset class that investors can trade. The data shows that the rise of these financial products is actually driving up the cost of divorce lawyers. Because firms know that a client has access to a $50,000 war chest from a funding company or an insurance policy, they are less likely to offer discounts or lien billing structures. It is the same phenomenon seen in the U.S. healthcare and higher education sectors. When third-party funding becomes available, the service providers raise their prices to absorb the new capital. This leaves the uninsured or unfunded middle class even further behind, as the market rate for a quality attorney is now set by what an insurance company or a hedge fund is willing to pay. There is also the actuarial divorce predictor technology. In 2026, insurance companies are using AI to analyze public data, social media activity, credit score changes, and even geographical relocation trends to adjust premiums for marital insurance. If the data suggests that a specific demographic or region is experiencing a spike in filings, the premiums for new policies in that area skyrocket. This is geographic risk pricing, applied to the American family. We are seeing a trend where residents of high-conflict jurisdictions, like Florida or Nevada, are paying 15% more for the same coverage than those in low-conflict states like Iowa. The insurance sector is also creating a demand for standardized divorce. To keep costs predictable, some insurers are partnering with fixed-fee law networks. If you use one of their approved lawyers, your divorce is handled according to a strict protocol. While this saves money, it limits the zealous advocacy that the U.S. legal system is built upon. We are seeing a macro bifurcation, a fast-track divorce for those with insurance-mandated limits, and a high-end conflict divorce for those with the personal wealth to fund a custom legal strategy. This brings us to the moral hazard argument. Critics of the divorce insurance sector argue that by making divorce affordable, the industry is inadvertently increasing the divorce rate. However, the macro data is inconclusive. What is clear is that these products are shifting the timing of divorces. People who previously couldn't afford to leave are now waiting for their policies to vest before filing. This creates a vesting cliff in the legal sector, where firms see a surge in filings exactly 48 months after these policies were first heavily marketed in 2022 and 2023. As we look at the financialization of the sector, it is evident that the divorce lawyer is no longer just a legal advisor. They are now a participant in a complex financial ecosystem involving insurers, lenders, and data scientists. The business of heartbreak has become a sophisticated market of risk. In the next part of this masterclass, we are going to look at the legislative and political lobbying arm of the sector. We will dive into how the American Bar Association and state-level legal groups influence the very laws that keep the sector profitable. We will examine the data on no-fault versus fault legislation and the multi-million-dollar lobbying efforts to prevent do-it-yourself legal reforms. If you think the laws were written for your protection, wait until you see who funded the drafting committees. Open the loop on the political machine that ensures the divorce lawyer always has a seat at the table. To understand the legislative architecture of the U.S. divorce lawyer sector, we must look at the structural capture of the rulemaking process. In 2026, the American legal system is not a static set of rules passed down from antiquity. It is a living, breathing economy influenced by massive lobbying efforts from state bar associations and trial lawyer groups. The macroeconomic reality is that the legal profession is one of the only industries in the United States that is largely self-regulated. This means that the people who benefit from complex, protracted litigation are often the same people who sit on the committees that draft the rules of civil procedure and professional conduct. Imagine a character named Jennifer in Virginia. Jennifer wants to use a simplified, AI-driven platform to finalize her uncontested divorce for a few $100s. However, she discovers that her state has recently passed consumer protection legislation that makes it nearly impossible for non-attorney platforms to operate without a licensed lawyer reviewing every single document. While this is framed as a way to ensure Jennifer doesn't make a legal mistake, the historical trend suggests another motive. In the last 5 years, legal trade groups have spent millions of dollars lobbying state legislatures to tighten the definition of the unauthorized practice of law. By doing so, they have successfully maintained a high barrier to entry, ensuring that the middle-class consumer has no choice but to enter the high-cost attorney ecosystem. Let's look at the data behind no-fault legislation and how it has been co-opted. Originally, no-fault divorce was intended to reduce conflict by removing the need to prove grounds like adultery or cruelty. However, the sector has adapted by shifting the conflict from the reason for the divorce to the consequences of it. While you no longer have to litigate why you are leaving, you now spend 3 times as much litigating the equitable distribution of assets. In 2026, we see that in states where the legislative language is vague, using terms like fair and equitable instead of equal, the billable hours per case are 30% higher. This is because fairness is a subjective concept that requires endless expert testimony, whereas equal is a mathematical calculation that requires a calculator. The legal sector consistently lobbies against bright-line rules in favor of judicial discretion, because discretion equals discovery, and discovery equals revenue. Step by step, the political machine operates through political action committees or PACs. In the 2024 and 2026 election cycles, state-level PACs funded by family law firms have been major contributors to judicial election campaigns. In many U.S. states, judges are elected, not appointed. When a law firm contributes to a judge's campaign, it creates an atmospheric incentive for that judge to maintain a courtroom environment that favors procedural complexity. If a judge were to streamline every case and cut through the motion practice, they would be effectively defunding the very firms that support their re-election. This isn't a conspiracy. It is a misalignment of macroeconomic incentives that keeps the sector bloated and inefficient. Consider the case study of the alimony reform battles in Florida and Massachusetts. For years, groups of obligors, people paying alimony, lobbied for clear formulas to determine how much and for how long support should be paid. They were met with fierce opposition from matrimonial lawyer groups. Why? Because clear formulas eliminate the need for litigation. If a computer can tell you exactly what the check should be, you don't need a $450 an hour lawyer to argue about it for 18 months. In 2026, the legislative compromise in several states has resulted in ranges, rather than fixed numbers, which essentially ensures that every single alimony case still requires a lawyer to argue where on that range the client should fall. The sector also exerts influence through court-annexed programs. We see a trend where state legislatures authorize the creation of mandatory parenting classes, mandatory mediation, and mandatory social investigations. While these are presented as social goods, they are often staffed by members of the legal and psychological community, who then cross-refer clients back to the law firms. This is a form of legislated demand. The law literally requires you to consume services that the legal sector provides. In a macro-analysis, this functions as a hidden tax on the dissolution of marriage, with the proceeds going directly to the professional services sector. Furthermore, we must analyze the self-help sabotage. In the year 2026, many county courthouses have self-help centers designed to help people file their own papers. However, macro data reveals that the forms provided are often intentionally designed with procedural traps. A single missing checkbox or an incorrectly formatted exhibit can lead to a case being dismissed or delayed by months. When Jennifer, our character from earlier, gets frustrated with the 50-page packet of free forms, she eventually gives up and hires a lawyer. The legal sector has successfully lobbied to keep these forms complex enough to be intimidating, but simple enough to appear helpful, maintaining the necessity of professional intervention. The macro impact of this legislative capture is a justice gap. While the wealthy can afford to navigate the complexity and the poor may qualify for underfunded legal aid, the American middle class is being squeezed out of the system. They earn too much for a pro bono lawyer but not enough to fund a 2-year legislative battle. This has led to the rise of legal desert counties where there are no affordable attorneys. Yet the laws remain so complex that residents are stuck in legal limbo for years. The industry also blocks multidisciplinary practices. In many countries, you can go to a single firm that employs accountants, therapists, and lawyers to handle your divorce as a package deal. In the US, the legal sector has fought tooth and nail to prevent this, citing ethical concerns about fee sharing. The result is that the consumer must hire 3 different professionals, pay 3 different retainers, and pay the lawyer to talk to the other 2. It is a fragmented market that maximizes the total spend per household. As we look at the political landscape of 2026, it is clear that the divorce lawyer sector is not just a participant in the law, it is the architect of it. The standard of care is constantly being raised, requiring more work for the same outcome, which effectively protects the industry's profit margins against the deflationary pressure of technology. In the final part of this deep dive masterclass, we are going to synthesize everything we have learned. We are going to look at the ultimate exit strategy. How do you navigate this $50 billion machine without being consumed by it? We will examine the emerging collaborative law models that actually work, the specific questions that make lawyers nervous, and the macro trends that suggest the entire sector might be headed for a massive tech-driven collapse by the end of the decade. This is the conclusion of our analysis of the U.S. divorce lawyer sector. Prepare to see the endgame of the marital estate. Open the loop on the future of divorce and the one thing the sector is terrified you will learn. The endgame of the marital estate is not found in a courtroom, but in the radical shift toward transparency and the technological disruption currently threatening the traditional billable hour model. As we conclude this macro analysis in 2026, we must recognize that the $50 billion divorce lawyer sector is facing an existential crisis. The one thing the sector is terrified you will learn is that the vast majority of legal complexity is a choice, not a necessity. By understanding the structural incentives we have spent 9 parts deconstructing, the American consumer is finally starting to leverage new models that prioritize the preservation of assets over the win-at-all-costs litigation mentality. Imagine a character named Thomas in Phoenix. Thomas has seen the wreckage of traditional litigation in his social circle. When his marriage reaches its end, he refuses to participate in the adversarial spiral. Instead, he looks toward collaborative law. This is a specialized legal model where both parties and their lawyers sign a contract at the very beginning stating that if the case goes to court, both lawyers must be fired and the process starts over from scratch. In 2026, this model has seen a 14% increase in adoption among middle-class families. Why? Because it aligns the financial incentives of the lawyers with the resolution of the case. In collaborative law, the lawyer only stays employed if they can find a settlement. This is the polar opposite of the traditional model, where a lawyer stays employed as long as the conflict continues. Historical trends suggest that cases using the collaborative model or high-fidelity mediation result in a 30 to 50% reduction in total legal spend. For a $500,000 estate, that means saving $50,000 or more in friction costs. But the sector fights this because it effectively caps the lifetime value of a client. Step by step, the industry is seeing a rise in unbundled legal services, where consumers like Thomas only pay for specific tasks. For example, Thomas might hire an attorney for a flat fee of $1,500 to perform a final review of his settlement agreement, rather than paying a $10,000 retainer for full representation. This is the unbundling of the legal sector, and it is the primary threat to the high-overhead, skyscraper office firms. Let us analyze the macro impact of the private judging trend. In states like California and Texas, wealthy litigants are increasingly opting out of the public court system entirely. They hire a retired judge to act as a private referee. While this costs $500 to $1,000 an hour for the judge's time, it saves tens of thousands of dollars in waiting time, at the public courthouse. From a macro perspective, this is the privatization of the judiciary. It creates a high-speed lane for those who can afford it, while the public system remains bogged down by the procedural traps we discussed in Part 9. However, even for the average citizen, the data from 2025 shows that simplified dissolution filings, where parties waive their right to discovery and trial, are becoming the preferred method for the debt-conscious younger generations. The rise of AI-driven dispute resolution is the final nail in the coffin of the old-world sector. In 2026, we are seeing the emergence of blind bidding platforms for alimony and asset division. Thomas and his spouse enter their ideal numbers into an encrypted system. The AI analyzes the gap and suggests a middle ground based on thousands of similar cases in their specific county. If both parties agree, the system generates a legally binding decree. This takes the negotiation out of the hands of the lawyers who bill by the minute and puts it into the hands of an algorithm that bills by the transaction. The sector's attempt to label this as the unauthorized practice of law is failing because the consumer demand for affordable outcomes is simply too high for politicians to ignore. Consider the case study of the divorce hotel concept or resolution weekends. These are intensive, multidisciplinary retreats where a couple meets with a mediator, a financial neutral, and a therapist over 48 hours to hammer out every detail of their split. The total cost is fixed, often around $8,000 to $12,000. Compared to the 18-month, $40,000 traditional litigation path, the efficiency is undeniable. The macroeconomic shift here is from litigation as a service to resolution as a product. The legal sector is being forced to pivot from selling hours to selling outcomes, a transition that is causing massive consolidation among smaller firms that cannot survive on fixed fee margins. We must also look at the pre-settlement audit tactic. In 2026, savvy consumers are hiring legal fee auditors before they pay their final bill. These are independent consultants who review legal invoices for the billing hacks we exposed in Part 4. Historical trends show that these audits often uncover 10 to 15% in overbilling, clerical errors, or unauthorized time shifting. The mere threat of an audit often leads firms to offer a professional courtesy discount on the final bill. This is the first time in history that the consumer has had the data to fight back against the 6-minute increment. The macro reality of 2026 is that the American public is becoming legal literate. People are no longer entering the lawyer's office as victims of a process they don't understand. They are entering as informed customers who know the data. They know that a forensic accountant should cost X, a custody evaluation should take Y weeks, and a retainer should not be an open-ended blank check. This shift in power is slowly deflating the bubble of the high-conflict divorce industry. As we look at the potential outcomes for the next decade, we see a move toward administrative divorce. There is a growing legislative push to move simple divorces involving middle-class assets out of the courtroom and into a streamlined administrative agency, similar to how we handle unemployment claims or small claims disputes. This would essentially remove the lawyer requirement for 60% of the population, a move that would save the American household billions of dollars annually. The legal sector is currently spending record amounts on lobbying to prevent this, but the macroeconomic pressure of the $34 trillion national debt and the shrinking middle class is making the status quo of expensive litigation unsustainable. The ultimate strategy for anyone navigating this sector is to treat it like a business transaction from day one. By removing the emotional fuel that the sector uses to power its billable engine, you can bypass the traps of the retainer loop and the conflict spiral. The future of the U.S. divorce lawyer sector is one of forced efficiency. Those who adapt to fixed fees and tech integration will survive. Those who rely on the predatory billing of the past will find themselves obsolete in an era of transparency. This concludes our 10-part macro analysis of the U.S. divorce lawyer sector. You now have the blueprint of the industry, the data on its hidden costs, and the knowledge of the political and financial machines that keep it running. But while the divorce sector is a $50 billion machine, it is only one part of the broader American legal and financial landscape. If you think the business of heartbreak is complex, wait until you see how the system handles the opposite end of the spectrum. In our next deep dive masterclass, we are shifting our focus to a different kind of high-stakes transfer, the Great Wealth Transfer, a macro analysis of the U.S. inheritance and estate law sector. We will explore how $84 trillion is about to move between generations and the legal sharks already circling the water to take their cut. The battle for the marital estate is over. The battle for the family legacy is just beginning. Open the loop on the inheritance traps that could liquidate your family's hard-earned wealth before it ever reaches the next generation.